Welcome to Building Families, Bridging Differences, a family law journey.
Hey everybody, welcome back to an all-new episode of Building Families, Bridging Differences, a family law journey with Shelly Cooley. I'm your host, Mike Leon. Shelly here is a certified family law specialist, and she's also the founder of the Cooley Law Firm out in Las Vegas. She focuses exclusively on family law, helping clients with divorce, custody, adoption, and assisted reproduction. And she's known for her compassionate, straightforward approach. I'm going to test her on that straightforward approach today. And in today's episode, we're going to be talking about how custody and support orders can change over time. Shelly's going to explain how the process works and what parents out there need to know. So Shelly, good to see you as always. Let's get into this. Once a custody or support order is finalized, can you kind of explain, is it truly permanent or can parents ask the court to modify it later on?
Thank you for having me, Mike. That's a very good question, and it's a question that I often get from clients. We've got two different types of orders we're talking about. We have custodial orders, and then we have support orders. Custodial orders are modifiable until a child emancipates or reaches the age of 18. And in order to be able to modify a custodial order, there has to be a change in circumstances. And depending on whether or not it is a primary physical custody award or a joint physical custody award, there's two different standards. But from the 10,000 mile view, you've got to have some type of a change in circumstances impacting the child's welfare in order to change custody. Now, when we're talking about child support is modifiable anytime there's an increase or decrease in income of 20%, an increase of 20% or a decrease of 20% in the individual who's paying support, or if it's a joint custody situation in either party's income. And then we also have every 3 years, pursuant to statute, parties are entitled to a review for modification of support.
Okay. So let me ask you, because I want to go back to something you just said there about changes, life changes. What kind of life changes usually qualify as let's say, a material change in the circumstances that could justify this modification?
One of the big changes that we often see is where the child will, something will happen in the child's life. Sometimes it's at school, sometimes it's at home, and the child will suddenly stop doing well in school. And it has to be a big change, going from an A student to, failing classes, or a child is suddenly missing a bunch of school. Then we would look to who is this happening with, which parent is more involved in school, and we would look at all of those circumstances to determine whether or not a change of custody is warranted. A court cannot change custody absent an evidentiary hearing. So if you are requesting a change of custody, you are going to have a trial unless the parties agree that custody should be changed.
Staying on the custody for a second, how can you kind of elaborate a little bit more? How does the court decide on these proposed changes and if it really is in the child's best interest?
We have the best interest factors that the court is required to address when addressing custody issues, whether it's an initial custody determined or a request to change custody. There are best interest factors. They're codified in statute. And the types of factors that the court looks at are the wishes and preferences of the child. If the child is of sufficient age and maturity to form a preference as to their custody. Now, that is very much a fact-specific inquiry, because you can have a 15-year-old who one would think would be of sufficient age and maturity, but isn't necessarily. And you could have a 12-year-old who is extremely mature and has a preference to live with one parent because that parent provides school support and helps make sure that the child gets to school on time and make sure that the child isn't absent and helps with homework and those types of things. So there isn't a magic age when a child is of sufficient age and maturity. It very much depends on the child.
Yeah.
We also look at the ability of the parents to cooperate and to communicate. That is one of the most important factors because parents need to be able to communicate with their children, or I'm sorry, to communicate about their children. And if they're unable to do so, that may support an award or a change of custody. We also look at whether or not there are other siblings in the home, the child's relationship with those siblings. We look at the age, developmental needs, social needs, the emotional needs of the specific child, and how each parent addresses those needs, or if there are special things that a parent does to address those needs and the other parent doesn't do, that would be a factor that the court would consider. And any other factors that the court deems relevant can also be addressed. So if there are specific factors or specific issues with this specific child, then that would certainly be something that we would raise before the court.
Yeah. Staying on the parents for a second, what about if both parents, because you said they need to communicate, right? So let's say they agree with each other on these new terms, whether it be something in court like a different schedule, adjusted support. Can they make a change now without having to go back to court?
Absolutely. It is common for those sorts of changes to occur, and parties may informally modify custody or a visitation scheduled by filing a stipulation and order. And what that does is that document, it's a pleading that gets filed with the court, but that document outlines the changes that the parties are going to agree upon and abide by. It gets submitted to the judge signs it, and then it becomes an enforceable court order.
What are some common mistakes, Shelley, that you've seen parents make when they try to handle those said changes informally or through, let's say, some text message arrangements?
The biggest issue with parties and um, modifying a custodial schedule or making modifications to custody is that they do not define things with enough specificity so that it can be enforced. You want a custodial order that has definite terms because when everyone is getting along, it's very easy uh, to go along and work together and figure out who's doing what, when, where. But when issues arise and you don't have a custodial order that has specifics as to exchanges, where they're occurring, who has what days, who has what times, and all of those types of issues, and parties don't get along, that's when you end up in court, and the court will enforce the previous orders, but they don't have specificity, so the court's unable to enforce them. So then parties have to go through a process where they figure out what orders should be so that they can move forward.
Yeah. Let me ask you on the financial side of this. How does someone request a change in the child or spousal support? And what documentation does the court need to see in that case?
With alimony and child support, with both situations, there has to be an increase or decrease of 20% in the person paying support's income. Additionally, with child support, you're entitled to a review every 3 years. You don't have that right when you're talking about alimony.
Let me ask you, Shelley, are there time limits or restrictions on how often a parent can request support or these custody modifications we've been talking about?
There aren't time limits per se. However, if you are filing a motion every year to modify child support, the court is going to view that as unreasonable. The statute allows every 3 years for a review. And if there's an increase or decrease in income of 20%, you can request a review and modification of support. But if you don't have those two factors met, then the court is going to be displeased and will likely. So if you file requests more than every 3 years or upon a change in circumstances, a court will likely deny your request for modification and may award the other party attorney's fees and costs if the other party requests them.
I see. Okay. So let me ask you, what happens when one parent then refuses to follow these modified orders? What are the enforcement options there?
So if a parent refuses to follow a court order, the other party has the option of seeking assistance from the court and requesting that the other party be held in contempt of court for failing to follow court orders. In order to hold a party in contempt, the orders have to be specific enough that a party can understand what is expected of their compliance. So again, going back to your custodial orders, it's very important that they be specific enough so that they can actually be followed. So if you have to seek assistance from the court in getting the other party to comply, the court actually has something to enforce for that party to comply.
Right. Shelley, as we wrap up here, for parents out there, maybe they're listening to this, they feel their current order, it no longer fits their current reality. What's the best first step or piece of advice you would give them to start this modification process in a calm and constructive way?
The first recommendation would be to call a family law attorney. I speak with clients often, or potential clients often, and we discuss their current situation. They discuss why they think custody should be modified or while support should be modified. And we go through the factors and we have a full discussion as to whether or not the court is likely to grant their relief. And at that point, with information, potential clients can make a decision with all of the information in front of them. They can make an informed decision as to whether or not they want to seek a modification or if they want to hold off and possibly seek one later.
Yeah. Shelley, thank you for the time and insights on this. We truly appreciate it as always.
Thank you for having me.
And thank you to everybody out there listening to another installment of Building Families, Bridging Differences with Shelly Cooley. If your custody or support order is no longer fitting your family's needs, Shelly and her team can help you understand your options, like she just told you, and guide you through the process with clarity and compassion. Do me a favor, visit CooleyLawLV.com to schedule a consultation with Shelly and the team. And don't forget to like, subscribe, leave a review and comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.